Good morning and welcome back to this, the third day, the best day of the Federalist Society's National Lawyers Convention. I am still Dean Reuter, still Vice President, General Counsel, and Director of Practice Groups at the Federalist Society. But now I'm also in charge of cleaning up the rooms after we finish here, so if you would please be careful with all your personal belongings, that would be helpful to me personally. So, what a great second day I think we had, and a great night last night. I thought Judge Jeff Sutton, was terrific as he delivered the Olson Lecture. So good, in fact, that we've invited him back to be on this morning's panel. In addition to having heard his lecture last night, I have read his book, and I recommend it highly. It embraces a view of law and the practice of law that is, I'd say, near revolutionary, but so obvious I wonder that nobody had come up with it before. So obviously correct that to not adopt his views, I think might rise to the level of legal malpractice. So. Yeah. Yeah. So you might want to buy a copy for yourself, but also for all your partners and associates to keep your firm out of trouble. So congratulations, Judge, and welcome back this morning. Our first panel this morning is titled The States in Administrative Law, and we've assembled for you this morning what I consider to be a truly first-class group of panelists, and I really do mean first class. I'm very proud of this panel, but that term, first class, gets overused sometimes, and that, of course, reminds me of a little story that takes me back over 20 years. And this story, it also happened in an airport, so it might be of interest to you for that additional reason, since many of you traveled by plane to get here. So 20 years ago or so, I was working for the federal government, and my children, who are now grown, were at the time very little. And I was a single parent with custody of my kids, so I tried to keep my travel to the minimum. But one time I had back-to-back trips, and I went to the extraordinary measure of trying to come home just for an overnight. But coming back on that first leg of the trip, I had severe delays, landing well after midnight at Dulles Airport. I was supposed to have arrived in time for dinner, tuck my kids into bed, and see them, but instead I was merely able to just peek in on them. I climbed into bed and set my alarm for an early morning flight out. My kids never saw me, although I did see them before I headed back to Dulles at daybreak the next day. And that morning I was in the check-in line, still dark outside, waiting at the check-in line, and I was at one of the budget airlines, which I would charitably describe as a younger airline. It no longer exists. It died before it reached puberty for reasons that might become apparent here in a minute, but I got to the front of the line and I saw an impossibly young man behind the counter to greet me. He looked like he should have been catching the bus to his middle school at that hour of the day. And I was wearing a suit. I had a well-worn trench coat, somewhat battered wheeled suitcase, a well-used briefcase. I looked just like the stereotypical business traveler. And so I was a little surprised when the young man, way too happy at that hour in the morning, asked me, "Is this your first time flying?" Now, having landed at that very airport just a few hours before, after midnight, in fact, that morning, I was able to reply somewhat snarkily, "This isn't my first time traveling today." So, and of course, that remark went right over his head. Anyhow, I was worn out by this time, and I thought I'd use my own money to try and get some extra leg room. So I said, "Do you have anything in the Economy Plus section?" "No, sir," he replied, without further elaboration. So now I was willing to plunk down my own money, some real money, to upgrade to first class. "Do you have anything available in first class?" I asked hopefully. And then without pausing, almost as if he had anticipated my question, he said, "Sir, all our seats are first class." Of course they are, I said, and by that time I was totally defeated. But our panel is truly first class. So. And I'm very pleased to introduce our moderator. If you want to applaud, you can. But, Judge Michael Scudder of the 7th Circuit, I believe, is making his first appearance at our convention as a moderator today, and we're very pleased to have him here. Incidentally, if you haven't noticed, we have I did the math on this, we have over 20% of the active federal appellate bench involved in the convention this year. So they're doing everything, including cleaning up rooms afterwards. So. Judge Scudder attended St. Joseph's College and then Northwestern University Law School, a very fine institution. He clerked for Judge Niemeyer on the 4th Circuit and then Justice Kennedy. He was at Jones Day Cleveland, which some people might know as the home office of that law firm, and then as an AUSA in the Southern District of New York. He's also served in the White House Counsel's Office and the National Security Council. He's been serving on the Seventh Circuit since earlier this year, and I'm very pleased to have him with us this morning. So please do join me in welcoming Judge Michael Scudder.
Thank you, Dean. Good morning, everyone. It's wonderful to be here. And I want to start by just introducing our panelists and diving right in to, I think, what will be a vibrant and illuminating discussion covering a range of pretty timely topics from a variety of perspectives. So to my left is my good friend, Jeff Sutton. Dean was right on the money, I think, in commending everyone that was not able to attend Judge Sutton's Olson lecture yesterday evening, featuring his book, 51 Imperfect Solutions, States in the Making of American Constitutional Law. I think Jeff is going to elaborate on some of the points and maybe expand upon a couple of aspects of the points he made yesterday. And just briefly, I think as most people here know, Judge Sutton serves on the U.S. Court of Appeals for the Sixth Circuit. He, too, is a former Jones Day lawyer, and it's actually the reason I joined Jones Day after clerking for Justice Kennedy. And of course, Judge Sutton served as the State Solicitor of Ohio, as a law clerk to Justice Lewis Powell and Justice Antonin Scalia, as well as Judge Meskel on the Second Circuit. To Jeff's left is Chris Green. Chris is a law professor at the University of Mississippi, where he also teaches as a scholar in law and philosophy. Chris graduated from Princeton, Yale Law School, has a PhD from Notre Dame in philosophy, clerked for Judge Barksdale on the Fifth Circuit, teaches in the area of constitutional law, including state constitutional law. So Chris, welcome. To Chris's left is Miriam Seifter from University of Wisconsin Law School. Miriam, graduate of Yale University, Harvard Law School, clerked for Chief Judge Garland in the D.C. Circuit and for Justice Ginsburg at the Supreme Court. Worked in private practice a bit at Munger Tolles in Northern California, and is here this morning to focus on an aspect of state administrative law that I think that we'll find pretty fascinating, looking at agency independence at the state level and what it says and doesn't say more broadly for the development of administrative law at the state and federal level. And to Miriam's left is Nestor Davidson from Fordham Law School. Nestor teaches in the area of property, land use, real estate, has a case book that came out last year on property law, practiced at Latham and Watkins, after graduated from Harvard College, Columbia Law School, clerked for Judge Tatel on the D.C. Circuit, and then Justice Souter at the Supreme Court. So welcome one and all, and why don't we start with Judge Sutton here and invite him to offer his perspective this morning on the topic that brings us together, the states and administrative law.
All right, thanks, Mike. It's great to be here. I think we're going to try to present in kind of the 8-minute, 10-minute range, and then start a discussion among ourselves, and then with you eventually. I'm feeling a little ashamed about all this book marketing. You might call it shilling. So a little full disclosure before you buy the book. So I'm very happily married to a 7th grade English teacher, and when I was about 6 months away from the book finally coming out, she said, maybe Jeff, I'll just read it once and, see if I have any suggestions. So a couple days later, chapter and a half in, she said, I don't love you that much. But she did read the book eventually. Why? When it was getting very close, a couple weeks, final page proofs, she's a 7th grade English teacher, she became embarrassed about the possibility that it would have some grammatical mistakes, so she read the whole thing cover to cover because she did not want the world to know that she was married to a dunce. So it is a little heavy sledding sometimes. So I'm going to give some kind of broader structural points. I hope that'll set this up, and a couple thoughts of my own. So one thing that's very different about what we're talking about today, when it's state structure, state separation of powers, is the difference between that and state individual rights. So when you have state individual rights, like their Bill of Rights with free speech, free exercise, and so forth, you have this two shots phenomenon where if you don't like what a state or local government has done, you can sue under the First Amendment's free speech clause, and you can sue under the counterpart of that state constitution. So that would be the individual rights world, where almost always you have two shots. Now when we go to structure, different story. The US Constitution does not speak to the structure of the states and their state constitutions. The Republican form of government guarantee in the US Constitution has been deemed judicially unenforceable to date. So that really, you don't have this overlay where you can look at a state separation of powers problem and say, aha, does the federal Constitution speak to that? Is there a second shot? Not really. I mean, you have to be a pretty imaginative and very persuasive advocate to get someone to think about it that way. That said, you still have the dialogue issue, where what's going on at the state level's highly influential to the federal level. And that goes back to the point that the state constitutions were really the ones that came up with our original separation of powers doctrines, concepts, language from 1776 up to 1787, and they really became the blueprint for what was done in 1787. The other thing you're going to find, and this might be a first in Federalist Society national conventions, you're actually getting an assignment today. It's unenforceable, but you are getting an assignment. I really would love it if everybody would take 15 minutes. I mean, we're already taking an hour and 45 minutes from your life. You're never getting back. So let's make it 2 hours. Spend 15 minutes and just read your own state constitution. No more than 15 minutes. You will be so struck by the differences in length, language, and often specificity about structure. So one reason for that is at the US level, there's only been one constitutional convention. That's it, 1787. Then 27 amendments after that. We know how difficult that constitution is to amend. At the state level, there's been over 300 conventions. The norm at the state level is lots of amendments, and that's in part because they're so easy to amend, 51% vote quite often. So you have a lot more specificity, whether it's structure and rights, and you'll really be quite shocked in that 15-minute overview. So one feature, this is something Miriam's going to talk about, a little more specificity, but one feature you'll see separation of powers-wise is a big difference between the unitary executive at the federal level and what I'll call the plural executive at the state level, where we have separate elections for state AGs, state secretary of states, auditors, and the like. That creates all kinds of fascinating separation of powers problems within the state. So having worked at a state AG's office, the one we saw all the time was who's in charge of the litigating position of the state? A separately elected AG, separately elected governor. It turns out, usually if you look at the case law is going to say usually the state AGs win that battle, at least as a matter of case law. I can tell you from experience in state AG's offices, that's really not what goes on. And I can illustrate it with a story. It may be legendary, but it happened before my time. It has a ring of truth to it. The governor, I think, was from a separate party from the AG at the time, so they had kind of an inherent reason to disagree. It was a politically controversial topic, and so the AG and the governor going back and forth about what the litigation position is going to be and exactly what the state is going to do on this particular issue. Finally, the governors had enough, and well, no, actually it goes the other way around. Finally, the AG has had enough, or so he says, and he says to the governor, okay, fine, we will do it your way. I will send a lawyer over in 15 minutes. So the AG, clever man, looks around the office, finds the greenest, youngest, goofiest looking guy in the office, gives him a yellow pad, a pen, and sends him over to the governor's office. Governor's office, knock, and in comes this young guy who doesn't know anything, and the governor within 5 seconds realizes, oh, this is not going to work. He says, why don't you wait outside, calls the AG back and says, you win. So control over counsel can actually be a lot more important than anything separation of powers says. So my last couple points I want to make is drill down a little more specifically on non-delegation and the Chevron deference issues. So my big gripe when it comes to state courts and state constitutions is that they too often lockstep reflexively follow what the U.S. Supreme Court is doing with similar guarantees, similar issues. That is very much a problem in the rights arena, in my view. It is not that kind of a problem in the structure arena. Turns out the state courts are really quite independent when it comes to construing their own structural issues and the structural guarantees in their state constitutions. I don't know if that's because those issues have less political resonance, whether it's because the state guarantees are so much more specific in terms of structure. I don't know, but there really is quite a difference. And you really see this in the gap between what's going on with the non-delegation doctrine, which at the federal level is actually a delegation doctrine. That's the better way to put it. On the federal level, there really is no non-delegation doctrine. Whereas at the state level, there really is a judicially enforceable non-delegation doctrine. Judge Ginsburg, Jim Rossi, Steve Menashe have laid out that it's really about at least half the states that quite seriously enforce that doctrine. And to me, that's fascinating, first for the states. I mean, it's really important to the lawyers. It's very important to what's going on in that particular state. But it's also quite fascinating for what that body of law means to the extent the federal side, the U.S. Supreme Court, the federal courts, reconsider, think a little bit more about the non-delegation doctrine on their side. Those state experiences sometimes can be quite relevant from an originalist perspective. Now, sometimes they're really not that relevant because the language of the state constitutions is so different. I think this experience, though, is most relevant when it comes to dealing with, I think, what has been the biggest practical problem with the non-delegation doctrine at the federal level, this concern about line drawing. And this was really seemed to be one of the things motivating Justice Scalia, who we all know cared deeply about structure, but was not someone willing to enforce the non-delegation doctrine. And it seemed for him, he was really quite concerned about the role of the courts in being able to manage that line. And what I think is fascinating, I think someone really needs to look at, is how the states are doing. Because if state courts can do it, it's really fair to wonder whether the federal courts can do it. So it becomes a question. On the Chevron side, real quickly, here the states are all over the map when it comes to deference to administrative agencies. It's really quite fascinating the number of state courts that are now taking quite seriously no deference, and not just for statutory reasons, but for constitutional separation of powers reasons under the state constitution. The Mississippi, Wisconsin Supreme Court's this wonderful opinion by Dan Kelly for the Wisconsin Supreme Court. Actually, the Wisconsin Supreme Court's really a great illustration of the debate within the state courts, because Justice Kelly's opinion is one that focuses on the Constitution and says no administrative deference is a matter of state constitutional requirements, whereas other justices on the court took a constitutional avoidance approach to the issue. So it's not clear exactly where that one's going. Now in Mississippi, it's a pure constitutional separation of powers issue. And what's really fun about this is you really do have a dialogue between the states and the U.S. Supreme Court, or in the case of Justice Gorsuch, the 10th Circuit, when it comes to this, how exactly to manage this Chevron line. But again, practical point. One of the great concerns at the federal level of getting rid of Chevron is this anxiety of, oh my God, how would this work in Washington with all these agencies without deference? Being from Ohio, I don't frankly care. That would be my first answer. But my second point would be, what happened at the state level? What happened when agencies didn't get deference? Did that really shut the agency down when it came to doing its job and administering this or that statute? So that experience too, not just doctrinally, but as a matter of practical, on-the-ground experience, what really happens there is worth examining. So I'll go on, let Chris go.
Yeah, we'll go to Professor Green now. He's going to share the results of pretty extensive survey work that he's done looking at decisions at the state level and their application or lack thereof of some doctrines that many in the room will know well that exist in federal administrative law, and what the experience has been at the state level as far as enhancing accountability and transparency vis-a-vis agency action. So, Chris, in your hands.
Well, thanks for the opportunity to be here, and I should say thanks especially for the opportunity to present something in such preliminary form. So last summer at the Southeast Association of Law Schools meeting, I was on a panel with Judge Sutton, and one of his former a law professor who had worked for the judge as an associate said, we joked we shouldn't get paid by the hour, we should get paid by the 50-state survey. And so I've got 3 surveys, but none of them are full 50-state surveys, so I worry that I shouldn't get paid. I mean, one of the most frustrating things I encounter just looking at state con law issues is the 35-state survey. So like, here's a whole bunch of states on one side of the issue. Here's a bunch of states on the other. Well, what about the others? And I maybe says something more about my presence on the Asperger spectrum that I can't even until I get a 50-state survey. But so what am I talking about? I'm also, I think, the only presenter at the conference with a handout, which I thought surely somebody else will have a handout, but probably just me, maybe somebody later today. But so these are 3 areas where judges are saying to state administrators, hey, you haven't explained yourself enough. 3 contexts in which that can happen. And they can draw an adverse inference from the failure to, they might or might not, draw an adverse inference from the failure to explain a result. Okay, so why might we want to have a doctrine like that? Because the experts might not know what they don't know. So the experts might think they know things that they don't actually know. So so Socrates was said to be the wisest man because he knew nothing. Hayek focused on what the government doesn't know about what prices ought to be. I don't remember the character of that. In Magnum Force, a man's got to know his limitations. Women and agencies, artificial entities. It's hard to know your own limitations. So part of the idea is, so you've got experts, they know stuff, okay, no question about that. One way to test whether the experts really know stuff is to have the experts try to explain it to a generalist audience, okay. As a normative matter, you might think, well, no. I mean, the generalist just can't understand it. The failure of the generalist to understand some area might just be like, well, it's like my failure, my 7-year-old to understand the sense reference distinction or something. Although my 7-year-old, my 3-year-old doesn't get it, but my 7-year-old does. So normatively, I really don't know, but I'm just trying to get a description. So the 3 areas are hard look review, where a court says, hey, you haven't explained yourself enough. The replacement of Chevron by Skidmore. Okay, so if you take away Chevron deference, you say, well, we're not going to just defer to you because the statute's ambiguous. One way to think about what happens when we cast Chevron overboard is you return to Skidmore. So Skidmore, of course, in 1944 says, even though an agency doesn't have authority, it might be able to persuade us. Anybody might be able to persuade. So Mike Rappaport says, well, we shouldn't even have Skidmore deference because, after all, private entities don't get deference. Well, maybe private entities should. Okay, so I've come into court. If I develop an expertise, I have consistency over time, all those factors giving me, or a lawyer, or the ALI, anybody, the power to persuade if lacking power to control. Well, you should defer to them in the sense of agreeing with them because they offer persuasive reasons. So Overton Park, State Farm say, hey, you got to give a reason for your regulation. Skidmore says you got to give a reason for your interpretation of the law. A third area is, I think, considerably less well known. It was abandoned by the Supreme Court, the U.S. Supreme Court, in 1931 in a case called O'Gorman and Young versus some insurance company, I think. So this was one of the, so 1931 you had O'Gorman, 1934 you had Nebbia, 1937 you have West Coast Hotel. So this is part of the surprisingly long story about the collapse of economic liberty under pre-New Deal, or kind of in the 1930s under the 14th Amendment. So in 1931, we had a case where a state came in and said, we're going to have some restrictions. And litigants came in and said, they haven't explained why we need these restrictions. You're telling insurers they can't, I was like, you couldn't have an in-state agent, or you had to have an in-state agent. It was on its face looked like rent-seeking legislation. Yeah, so I got my little deadweight loss diagram there. So it looked like that. It looked like you're just trying to restrict supply to redistribute wealth to the sellers, harming society but benefiting particular insurers. Okay, and the four conservatives on the court said, hey, in order to justify the denial of this right to make private contracts, some special circumstances sufficient to indicate the necessity, therefore, must be shown by the party relying upon the denial. They're in litigation, okay, so you're arguing to an agency, hey, this regulation doesn't make any sense. The administrator says, well, it's up to you to show that it's unconstitutional. It's not up to me to show that it's justified. I have to have a reason for a regulation. So in 1931, the Supreme Court says, yeah, we're not going to draw any adverse inference from the failure of an administrative agency or a litigant to justify that regulation. It seems to me, looking at just the early state constitutional law, that state courts exercising judicial review have a duty not to leave evidence on the table, not to fail to make proper inferences from things like that. So I cite in the handout a bunch of early cases. I call this the duty to clarify. So you have a duty not to strike down statutes unless it's clear that a statute violates a state constitution. But you also have a duty to clarify, and that means not leaving evidence on the table. So these are three places where a court can tell an agency, hey, you haven't explained yourself. There's a bunch of other people who might tell an agency, hey, you haven't sufficiently explained yourself. So this is, I think, going to become an article, 10 ways to make state administrators explain themselves. I'll just rattle some of these off. What's a non-delegation doctrine? It says, hey, agency, you can't just adopt this. You got to persuade the legislature. A bunch of non-expert generalists, so you could have to persuade a legislature. You could have to persuade a state OIRA, which is what Miriam has looked at in great detail. You might have to persuade other agencies. Hey, we've got a stake here, so that would be another way that a state OIRA would be involved. You might have to persuade the agency itself. So if you have a separation of prosecution and adjudication within the agency, New Jersey and Georgia, I'm told, by people at this conference, have that sort of doctrine. You might have to persuade the agency at a later time. So the agency adopts a rule, but it might be easy to reverse it. So Fox versus FCC issues at the state level would be important. And there's a number of other doctrines that allow future agencies to reverse decisions. So unless the agency makes a persuasive case to its future self, that's not going to last. Finally, you might have the public. So a transparency requirement says, hey, if you're going to do something, you got to tell the world and give them a chance to overrule it. Talk to their legislature. that's less effective. You might have juries. You might bring in 12 members of the public and say, well, we think, we should be at quantity 1 instead of quantity 0 on this thing. We think we should ban cigarettes. What do you people think? And I mean, that would be, as Philip Hamburger says, quite a limit on agency. So anyway, am I out of my 8 minutes? Maybe close to it. But there is exciting stuff going on in all of these areas. So William Funk in '91, I think, is, as far as I found, the only one to kind of assess the ground of hard look review in the states. He thinks, in 1991, he said it looks like a lot of states don't have hard look review. I couldn't find that many. Wisconsin was actually one of them, but not too many. It was a little unclear in Florida, but lots and lots of states had something like hard look review, at least in name. Maybe Funk suggested that it was just boilerplate, a lot of them, but if you want the cites and want to, if you have a regulation, if no one else can help, maybe you can cite one of these cases. Chevron, there's been 4 states that have cast it off this year, and 4 different ways. So Mississippi cast it off quite summarily and suddenly and unanimously in our King case a few weeks before the extremely extensive and widely discussed at great length opinion in Wisconsin. Arizona got rid of it by statute, and then Florida got rid of it by constitutional amendment. Beyond those, you have a lot of states that the way they apply Chevron or the way they apply deference really has a much more Skidmore flavor to it. So some people call that Chevmore, the blend of Chevron and Skidmore. Justice Breyer's approach in the Meade Corp line suggests that the trigger for Chevron deference is giving a persuasive reason. Okay, that's essentially like having Skidmore instead of Chevron. So there's lots of cases citing that. Finally, in O'Gorman, you find a bunch of states that actually do draw an adverse inference, including Florida. They say, O'Gorman, that's not the rule here. If an agency doesn't give an explanation for why they're doing it, we're going to draw an adverse inference. That was 1984. I mean, it's maybe feels like a long, long time ago, but it's this is a long time after 1931. So there is quite a lot of ferment. I hope to have 50 state surveys of all these 10 areas, so 500 rules of law nailed down at some point. But watch, not this space, but Google my name at some point in 15 years and see if I ever do get these 10 surveys done. So thank you.
Thank you, Chris. So Professor Seifter has an article that I mentioned coming out in the Michigan Law Review early next year. Is it, Miriam?
Yeah, that's right.
And exploring a very fascinating topic, and perhaps for the first time that it's ever really been looked at, and that is agency independence at the state level. We know well considerations of agency independence at the federal level, and lots of debates, lots of case law, and lots of ink spilled on just how much independence is required of the president for an agency to be independent, and whether broader structural questions about whether that's even constitutional or not. But Professor Seifter is looking at this at the state level, and her forthcoming article, I think, pays particular focus to considerations of independence between a governor and state agencies. So with that, we'll ask for an overview and listen attentively.
Thank you so much. Thank you. So I'm very happy to be here. I'm pleased to be on a first-class panel. I didn't realize that was going to be the case, and I'm thrilled to be on a panel that's focused on the states. I could not agree more with my co-panelists that states are really worth studying. States are, of course, deeply important in their own right because it's state governments, after all, through which most of us experience regulation. And state approaches to common problems can also provide an instructive comparative lens, reminding us that there is more than one way to do things. So, as Judge Scudder said, I'm going to talk today about what agency independence looks like in the states. And by agency independence, I mean the relationship between executive entities and the chief executive, so of course the president at the federal level and the governor at the state level. My focus won't be on the normative question from yesterday's terrific panel on agency independence, which was how much agency independence is too much, because I think in the states we actually need to take one step prior to that and just try to unearth a descriptive picture of what is happening. So what are the legal contours of agency independence in the states? This is more than just an academic question. Take a recent conflict in Arizona. Was there anything unlawful or incongruous about a proposition that just passed, giving the governor more authority over the state's Clean Elections Commission, which had identified itself as an independent body? Or for that matter, was it constitutionally required for the governor to have that sort of authority over the commission? Or take North Carolina. Was it permissible for the state legislature there to divest the governor of substantial power over certain executive commissions? Or in a number of states, as Judge Sutton alluded to, what if the governor and the state attorney general disagree? So the question I've been looking at is, what is the going legal framework for analyzing these questions? I've studied state constitutions, state legislation, and state judicial decisions, doing the beloved 50-state surveys, and I've looked specifically at issues like the selection of an officer, the removal of an officer, and then the ability of the governor to direct the officer once they are in office. Well, for the full story, you can check out my forthcoming article that Judge Scudder mentioned, but it's barely 10 a.m. You don't want to read that, so I'm here to give you the Cliff's Notes version. My thesis basically is that states approach agency independence very different from the way the federal realm has approached it. States employ a version of agency independence that is different for different agencies, unclear legally, and unstable over time. So to flesh this out, let me draw out 4 big picture differences, and I'll draw upon differences regarding state constitutions, state courts, state legislatures, and state norms. So first, differences in state constitutional law. Perhaps this is the most obvious difference. It's the one that Judge Sutton mentioned. Almost every state constitution creates what we can call a plural executive branch, in which multiple officers are first of all created separately from the governor, and then many of them are also elected separately. So this obvious difference might seem to lead to an obvious conclusion that states are therefore home to a more robust independence kind of all around. But that conclusion is actually not obvious, and in fact, most state courts have not so held. And the reason for this is that most state constitutions also have clauses that empower their governors, often to a degree that's not present in the federal constitution. So many constitutions say that the governor has the, quote, supreme executive power. A number of state constitutions have gubernatorial supervision clauses or particularly robust take care clauses, all of which seem to support an argument for gubernatorial control. Now, the positive law picture gets even more complex once you fold in state legislation. One of the things that I found really interesting in my study was that the vast majority of officials within the plural executive branch nationwide, the state constitution leaves either all or some of their powers to state legislatures. So a typical formulation is something like, there shall be a state treasurer with duties to be prescribed by the legislature. And many state legislatures have, at various times, particularly during times of executive branch reorganization, decided to give the governor power over various executive officials, including those that might sort of superficially seem to be independent. So in many states, the question of independence presents an interpretive challenge. Now that leads me to the second part of our descriptive journey here. What have state courts done in confronting this challenge, and how is it different from what federal courts do? So to paraphrase everybody's favorite administrative law case, United States versus Meade, that was an administrative law joke, the states have generally tailored independence to variety. Now, there are a few state courts that don't fit this description. So there are a few state courts that have held that the governor's supreme executive authority means that the governor has to control all agencies. And on the flip side, there's at least one state court that has indicated that the plural executive structure creates a sort of categorical constitutional independence across the board. But most state courts have proceeded with what I call a non-binary, non-categorical approach. Non-binary because they don't divide the world into independent agencies and not independent agencies, the way we sometimes teach at the federal level. And non-categorical because most states don't even use the term independent agency. It's not a thing, as my students would say. And they don't use any similar, synonymous term to invoke this idea that there's a trans-substantive category of this thing called an independent agency. Most state courts also don't assume from the presence of one factor, like let's say tenure protection, that an agency must fit some set predetermined mold of independence. Instead, most state courts resolve questions of independence in a clause-based and context-sensitive way. So for example, it's not unusual for a state court facing an intra-executive dispute to say, okay, this is an officer or agency that the governor either doesn't appoint because they're separately selected, or whom the governor can't remove at will. But that doesn't preclude us from concluding that the governor can nonetheless direct or veto this agency or official over certain decisions if that's the best reading of the statute. Now, it's kind of worth noting here that this state approach resonates with what I think is a rising critique regarding federal jurisprudence on agency independence and on the separation of powers more broadly. Scholars of varied perspectives have argued that federal courts do too much abstracting on these issues. John Manning, for example, has argued that there is no freestanding separation of powers doctrine, and so courts should engage in what he calls ordinary interpretation of the most relevant clauses at issue. Similarly, on the specific topic of independent agencies, Kirti Datla and Ricky Revesz have asserted an idea that courts shouldn't embrace abstractions about agency independence either. They should just follow the terms of whatever the statute says. So the states present this real-life judicial system in which to see this alternative approach in action. Okay, the third difference I want to talk about has to do with legislatures. State legislatures, and for that matter, state initiatives and state referenda, have played a more active role in tinkering with agency independence over time. I think this is different from the federal realm, where we often think of at least the highest levels of agency structure as part of the rules of the game, right? Those features that stay put even when political fortunes change. So even if Congress, for example, is upset with the decision by, say, the FCC, we don't imagine that Congress's next move will be to change the FCC from an independent agency to an executive agency. Or at least that would be a big deal. But state legislatures do that pretty regularly, as I document in the article. Now, one implication that's worth noting here is this sort of legislative volatility raises the possibility that it'll really undermine independence in a deep way. Right? How independent can you be if your independence itself is up for grabs depending on what you decide? Okay, the fourth and final difference I want to point out has to do with norms. The state sphere may reflect weaker norms about what independence means. Now, I think partly this flows from the legislative volatility I've described and from the lack of a categorical judicial approach to independence. In other words, maybe agency independence in the states is just too much of a moving and evolving target for a strong norm to emerge. Partly, it may also be because state legal communities tend to lack some of the norm-producing institutions that the federal government has. Most law schools, to Judge Sutton's and my disappointment, don't teach classes in state constitutional law. And also, not all state executive branches or state bars have entities analogous to, say, the Office of Legal Counsel, who really devote their time to developing a keen and lasting understanding of executive power. So unlike at the federal level, where scholars have recently been documenting how unwritten rules regarding independence actually explain a lot of the behavior that you see from both presidents and agency officials, in many states the issue seems to be more up for grabs. Okay, so let me close with just a few implications of these findings. The first, and this echoes something that Judge Sutton said, is that state courts deserve credit, I think, in this area. They're dealing with really challenging materials. They are not lockstepping with federal law the way they're sometimes criticized for in other areas. And these cases are really a rich resource for anyone who's interested in studying executive power. A second implication has to do with what I think of as the twin effects of precision on one side of the coin and uncertainty on the other. So state legislatures' practice of creating different independence for different agencies and then changing it over time and state judicial practice of hewing to those choices have this sort of democratic appeal. Maybe the people are getting basically exactly the independence they want in each different context. But the flip side of that sort of narrow, clause-based, context-specific approach may be that the law is less certain and less predictable and harder to anticipate for any given actor. Now, this raises a question about practical effects. In particular, does the uncertainty and instability for some officers mean that they have less operational independence? And really, this is a question rather than a statement. But even if the law makes them nominally independent, will they feel less independent because of the sort of role in frequently revisiting their independence? And then finally, whatever the answers to these other questions, I'll come back to the value of teaching state administrative law and state constitutional law in law schools. It can add so much to our understanding and to our discourse. And in all events, I'm happy to be on a panel highlighting state law, so thanks for having me today.
Thank you, Miriam. Nestor Davidson has done some work and published it in the Yale Law Journal, if memory serves, on administrative law at the local level, at the municipal level, at the county level, at the village level, and is going to offer some perspectives today on what we can learn from administrative law at that level.
Thank you so much. And thank you all for showing up at 9 o'clock in the morning on a Saturday to think about state, and I will now add local administrative law. We literally have people in the rafters. This is pretty stunning. So thank you. I also think it's a particularly timely moment to be thinking about the sub-federal level. Given the nature of the hydraulics of policymaking in this country, at a moment when we are at a fairly deregulatory having a very deregulatory moment at the federal level, and some gridlock on areas where the federal government has been traditionally very active. A lot of the energy for regulating is moving to the state and I think local level as well. And so I think it's appropriate, as governance is devolving in many areas, to be paying very close attention to the mechanics and the law that is governing that devolutionary regulatory environment. So my brief this morning, as Judge Scudder mentioned, is a pretty simple one. I want to argue that it's important to pay attention not just to the critical questions at the state level about agency independence, about deference, but to add the local as well. And Miriam has unpacked some of the horizontal questions that are so critical, and let me try and unpack some of the vertical questions within the states that I think are also fairly critical. So to begin, I think it's important to remember that much of what we think of as within the realm of how states operate through local governments. And whether we think that local governments are an arm of the state or a local polity or some hybrid version of that, many areas in our federal system that we delegate or that have begun as matters of state competence and importance are really exercised through local governments. And it's terrific to be focusing, as Judge Sutton has done, on individual rights at the state level, but individual structure I think is equally important. So much of what local governments do, and this is not just in the delivery of services, which is obviously a critical aspect of what cities and counties and suburbs and small towns do, but also as regulators. And local governments are increasingly acting as regulators. They do through administrative bodies. And on the regulatory front, local governments are increasingly involved in regulating everything from workplace conditions to public health, to the environment, to technology. Many areas that I think maybe a generation ago we would have thought of as largely federal areas of concern, that states have always been involved in to some extent, are really increasingly playing out at the local level. And that's true not just for large cities, but also for smaller local governments. And if you look at how local governments are structured, and not just in New York or DC or Los Angeles or Chicago, but Oak Park and Tuscaloosa and Barrow, Alaska, and I spent a lot of time looking at the structure of lots and lots of local communities. You will find a little mini version of the alphabet soup we have in terms of agencies at the federal level. You'll find a really remarkable array, even in relatively small communities. And when I was working on this article, I would go around the country giving versions of a talk about the article, and wherever I was, I would Google the night before that particular local government, and you could always find 10, 12, 15 agencies, even in the smallest community. It became a little bit of a parlor game. But you'll find health departments, zoning boards, school boards, police commissions, an entire panoply. I like to call this, it's not so much the administrative state, but it's kind of an administrative city-state. It may not be the FCC, it may not be the EPA, but it's actually a very important layer of governance. And if you think about where governance happens today in the United States, 1 in 38 people in the country live in New York City, where I live. New York City has more people than Idaho, Montana, Wyoming, North Dakota, South Dakota, and Nebraska combined. More than 80% of the people in the country live in urban areas, and in many important respects, cities, suburbs, counties are the most important regulatory layer for them. So let me just say a few words about structure. Structure is obviously critical to doctrine, and it's important to pay attention to structure. And as interesting as things get on the state level, and they get very interesting, I think they get even more interesting when you turn the lens on the microscope and begin to look a little bit lower in the Federalist stack. So, for example, many local governments have little or actually no separation of powers whatsoever. In many local governments, you have a legislative body that also happens to have an executive as part of it, or you may have no recognizable, at least elected, chief executive at all. We tend to think of a model of the mayor, because that's our popular culture, and certainly, again, I live in New York. We have a very strong mayor, relatively speaking. But in more than half of all local governments, the person who we would think of as the chief executive of the executive branch is just an appointed civil servant, a city manager. And they just perform functional duties. Important, critical, but there's no electoral responsibility. So forget what we know about the unitary executive at the federal level. Imagine a system where courts are reviewing action by a government that has no executive, or at least no elected executive. And what does that mean for how we think about separation of powers? What does that mean for how we think about deference? Similarly, and I think this is really important, local governments and local government agencies in particular often have a dual structure of accountability. So local agencies are accountable in the way we traditionally think of federal agencies towards both the executive and the legislature in their local government of general jurisdiction. And it's hard, as hard as it is for 51 jurisdictions to draw generalities, there are over 90,000 local governments in the United States, so I'm radically oversimplifying here. But many, many agencies are accountable both to their local government of general jurisdiction and also to the state. And in many instances, they may have power delegated directly from the state to an agency. And so we get into these very interesting, almost triangular relationships between agencies whose jurisdiction is at a particular locality, who may have a close or a distant relationship, talking about independence from the general local government, but may have an even closer relationship with the state itself. And again, as we think about a jurisprudence of accountability and transparency, which is really what we're talking about this morning, that dual reporting structure and how much power the state delegates to a local government is really critical. So briefly, how might we think about what's different, taking a step back, about the context and the structure, and what does this actually mean? I think it's important to recognize there are reasons why courts, and here, again, to be clear, these are mostly, the jurisprudence that's developed around state administrative law and certainly around local administrative law is largely a body of state law. It's state courts reviewing state actors, which is not to say the federal courts don't have something to do with that, but they're largely not at the center of this conversation. So how do state courts approach this? I think there are reasons why at the local level, whatever we think about state structure at the local level, we tend to see less deference. We tend to see a more intrusive local jurisprudence to the extent that courts disaggregate at all, and they generally don't. But I think you see concerns in the jurisprudence about capacity at the local level, about expertise at the local level, about informality. In roughly half the states, there's no equivalent at the local level to a state administrative procedure act. Having practiced in land use, when I began as a young lawyer and dutifully looked for what procedure governed when we were trying to get some zoning change, I was often very surprised to realize that nobody had any idea what the procedure was, and you would go into a board and kind of make it up as you went along. And that's not unusual, and courts do some work in imposing formality, but really not all that much at the local level. And then I think some courts are concerned about parochialism and scale and the tendency of some local governments to really not internalize the external effects of what their regulatory choices are. In this article, I also lay out some arguments for why we might actually give more deference, or courts might actually give more deference at the local level. This hasn't really shown up in the jurisprudence, but I think it's important to have out there. I do think subsidiarity is a really important principle. I think recognizing that in many regulatory areas, land use being a good example, the level of government, to cite the cliche, that is closest to the people who are being regulated, should be able to regulate. And that's not necessarily only a question of power, but that's also a question of deference. So I think scale can be a reason for giving more deference to the output of local agencies. I also think there's a different kind of expertise you get at the local level. So if you think about the kinds of areas where local governments may regulate best, it is a kind of tool. Local governments can be a kind of tool to aggregate a particular kind of local knowledge. And if you think about how a state, in the generic sense, sees, local governments have an ability to see in a more precise, very localized way, and that's a reason for perhaps giving a little bit more deference. And I think the fact that the public is much more involved. So if you think about zoning boards and school boards and police commissions and a lot of local administration, whether it's in the kind of quasi-lawmaking context or in the more discretionary application of delegated authority, a lot of local administration is marbled throughout with public involvement in a way that's unusual at the federal level. And I do think that kind of inherent involvement of the public, which has lots and lots of downsides, may have some upsides in terms of legitimacy and a ground for deference. So let me just close with one brief doctrinal example and then look forward to the Q&A. And we, I think, can talk about what a localist Chevron or a localist Skidmore or a localist Chevmore might look like. But let me pivot to something that Judge Sutton mentioned, which is non-delegation doctrine. And it is true that non-delegation doctrine has more teeth at the state level. It has a lot of teeth at the local level. And this is really the doctrine that got me interested in thinking about the interplay between courts and local administration. And it's fascinating to see that state courts demand at the local level, again, recognizing how hard it is to generalize across 90,000 local governments, but in the main, for all of the many cases I've read in this area, state courts really do demand a much more precise specification of the authority that has been delegated to an administrative body. In the article, I give one example of a case out of Maine where a zoning board was given the authority to review land use decisions, something called conditional use permits, and the standard was that they had to evaluate whether or not the change in zoning would, quote, conserve natural beauty. And for those of us who look at the state of delegation at the federal level, that's not much more, I mean, that's actually more precise than regulate the airwaves in the public interest, right? That would likely be upheld at the federal level, but the court in this particular case said that was not nearly specific enough and struck down the exercise of that delegated authority. And that's a very typical example. You often get state courts saying, if a legislature, if a city council or county council or another local legislative body is going to give discretionary authority to a zoning board or a school commission or the like, it has to be very precise in the metes and bounds of that delegation. And we can debate the merits of that, but I think it's interesting to note that the sort of lower you go down in our Federalist structure, the more courts may be actually requiring some precision in this kind of accountability conversation. So I'll just close by saying I think it's important if we think about the states to disaggregate between states and local governments. I think there are many areas where the doctrine is very similar and appropriately so, and I think that's true of federal, state, and local. But there are many areas where, as Miriam mentioned, if you look very specifically at a given agency and the given statutes that govern it and the given structure of a particular local government, you're going to come to different answers than you would certainly at the federal level. And so I think it's very important to pay attention to those given contexts, and I don't think state courts often do that enough, and I think we could have a more intentional jurisprudence as we think about the kind of plurality of structures, and that holds important comparative lessons as well. Thank you.
So I want to open it up to the room. I'm sure there's some questions from the podium, but invite anyone with questions. There's microphones on the side aisles, or raise your hand and speak loudly, and we can get some dialogue going in the room here this morning.
Good to know you're not all leaving. You're actually going for the microphones.
Let me put a question. Let me put a question out there.
I have to say just one thing. I've already decided what I'm doing in my retirement years. I want to be the first person in American legal history to do the 90,000 city survey.
I've tried. It's not easy.
That is going to be so awesome. It's definitely going to be a book, right? I mean, that's not an article. That's a book.
I had two bad jokes I wanted to tell. So if you have a non-delegation doctrine at the city level, a city can't just have a dictator.
Right.
So you can't have Cincinnatus for Cincinnati.
There you
right?
go.
So has it been taken? So I'm looking for a crazy idea about hard look review that'll like expand the range of get something from off the wall to on the table to expand the Overton Park, Overton window. So anyway, you won't ask me back.
Okay, we got a queue. I see Steve Calabresi.
Steve Calabresi. I'm the chairman of the Federalist Society Board of Directors, and I wanted to begin by commending this panel for a fascinating discussion about state and local administrative law. I also have to apologize. I have laryngitis, so can't be heard very clearly. But my question was particularly directed to Judges Sutton and Scudder, but I'd be interested in what the other three panelists think of it as well. And it goes to something that I learned from Judge Ralph Winter when I clerked for him in 1983. And he said that when he was young and in law school, there used to be a saying, don't make a federal case out of this. And Judge Winter said in 1983 that saying should be amended to mean, don't utterly trivialize this. In other words, a lot of things that are very trivial are finding their way into federal court that may properly belong in state court. My question for the two federal judges and for the other panelists is, if you have a filing before you or an appeal before you that raises some important federal constitutional question, say on a controversial issue like abortion or affirmative action, would it be appropriate to ask the plaintiffs to amend their complaint to add any state constitutional law claim that they could have, so that the court would have the option of deciding the issue on state constitutional grounds rather than federal constitutional grounds? The federal interest in that is that if a federal court of appeals decides a case on state constitutional grounds, its ruling can be overruled by the state Supreme Court. Its ruling applies to only one state, not to the 3 states in the 7th Circuit or the 4 states in the 6th Circuit. And it might be compatible with the discussion in Younger v. Harris about the importance of our federalism and of emphasizing the role of the state courts. Any thoughts?
Well, I love that question, Steve, and I've thought a lot about it, and I'm so disappointed I haven't come up with a way to say yes, because I so badly want that to be the answer. What you're really saying, and what I think makes a lot of sense, is an exhaustion requirement, and a way to think about this doctrinally is most federal constitutional claims run through the Due Process Clause, right? That's incorporation, the Liberty Clause.
Right.
And so you say to yourself, why wouldn't you ask yourself if there's any way in which the state could fix this problem short of there being a federal constitutional problem? And it is, after all, a due process clause, so it implicates, suggests process. That process could include avoidance, interpret the state statute to avoid the problem. It could involve a state regulation, and of course, it could involve the state constitution, which would take the problem off the table. But I don't think there is an exhaustion requirement. I don't think there should be one, and I think our federal rights are our federal rights. And if someone's violating them, if you want to go to federal court and just take one shot, not a very good basketball player, but take just one shot, you're frankly allowed to do that. Now, I will say at the state level, Oregon's a really good example of this. They do have this exact exhaustion requirement under the state constitution and federal, but they're allowed to do that as a state court. Right. The only other thing I would say, which is implicated by your question, is when you do have two claims, state and federal, in the federal level, it's often a very good idea, I think, for the federal court to certify the state constitutional claim to the state Supreme Court. In fact, for a litigant, it can be a really quick way to get something to the state Supreme Court. You try certification at the federal district court level, boom, you're right there to the state Supreme Court. Unfortunately, this is something I've been working on with state court judges. I basically think the certification process is broken. I blame state court judges in part because it takes a little too much time, and I blame federal judges because we're too impatient. But we've got to fix that system because it would be quite respectful and very federalism driven.
Yeah, Nestor, go ahead.
I just want to add one footnote to this discussion, which is we do have one area of constitutional law where we have this kind of exhaustion requirement. For now, and the Supreme Court's going to look at it, and it's been very fraught, right, which is in the takings context, which is to say that before you can bring a federal constitutional takings claim, you have to decide whether or not the state has or has not given you just compensation, and in order to do that, you have to go through state process. And the Supreme Court's going to likely decide this year whether or not that exhaustion requirement will survive. But it has been quite controversial, and it's created a lot of tension, precisely for the reason that Judge Sutton pointed out, which is that a lot of people believe that it denies the ability to get into federal court on the core question of a federal right. It does, as a practical matter, require you to litigate questions of federal takings law in state court and then be precluded if you then try and go back to federal court. So I think that there are complications here that we should pay attention to, and the takings clause is an area where we actually do have a body of law on that.
And there's something to be said for having the same rule for all the rights. You could have Williamson County for everything, but that would be different.
Okay, we'll shift over to this side.
Okay, Stephen Casey, Austin, Texas Lawyers Chapter. Given the last 10 years, there's been an increased groundswell of people moving to Texas, and anecdotally, been documented from high tax, high regulatory states like New York and California. I'd be interested in the panel's perspective. Do you think it's going to lead to a feedback in those states from where they're moving to a lessening of the regulatory burden and lessening of the administrative state? Or do you think that it's going to just boost Texas a little bit and turn it a little more purple, I would guess, than blue?
Well, yeah. A lot of those people from Mississippi, it tends not to. I mean, I think take our best people, and it makes Texas better, and makes Mississippi a little weaker.
Do you guys go ahead?
I would just say one thing about that, which is that people are moving to Texas, of course, but in many ways they're moving to Austin, and they're moving to Dallas, and they're moving to Houston, and they're moving to San Antonio. And I think one dynamic that we already see is that we have a greater level of friction, and I think it's really developed over the last 10 years. It's always been there, but it's increasing with mobility between the policy preferences at the state level in a place like Texas and the increasingly divergent policy preferences in a place like Austin. And those conflicts are playing out largely as a question of home rule, immunity at the local level, but I think as cities, because really, Texas has 4 of the, if you look at the top 10 fastest growing cities in the country, 4 of them are in Texas right now. And I think it's really the urban areas in Texas that are drawing population, and that is increasing the political power, relatively speaking, within the state. The state may not be purple, but there are some really deep blue pockets within Texas, and in the midterms, there was a story that could be told about even the area around Fort Worth, which has traditionally been a relatively conservative urban area, is now trending more democratic. And I think a lot of other factors are driving that mobility, but I do think it's a stark reality, and I think you can tell a similar story in Georgia and North Carolina and Florida and other places. I think it's going to increase tensions between the cities in a place like Texas, the Texas Triangle, and the state.
Go over here then. Sir?
Thanks so much. Each of the panelists have talked about the very distinct differences of state administrative law from federal administrative law. Judge Sutton urged us all to read the local state constitution. Professor Green remarked upon the tyranny of the 50-state survey. Professor Seifter said, no state administrative law in law school. And Professor Davidson said there are distinct local doctrinal differences in non-delegation. So what I'd like to do is have the panel act as our ad hoc marketing firm. And I'd like a marketing suggestion from each of the panelists about how local lawyers can highlight in an educational way the distinct local and state differences to the bench and bar. What suggestions about highlighting the differences would each of you give us?
May I recommend my forthcoming article?
I would second that.
I mean, Judge Sutton's book, really, is far better marketing than I've ever seen. It's great.
We should read each other's stuff, and
Yeah.
I should write my stuff.
But I would like to do the bias more to what they've written, and I really would read what they have written. I mean, knowledge is power in this area. It blows me away the number of disputes locally, city versus state, going on where people are not paying attention to the things that we so obsess about at the federal level. Now, of course, that makes sense. At the federal level, the stakes are so high, you can afford to hire 100 lawyers to figure this out. You cannot normally do that at the state and local level. But there are just so many opportunities here to help a client, I guess is the way I would put it. And you read these things and you're just so shocked. Is no one's paying attention to this? And I think the last point that Nestor made, that we have red, blue statewide, and then within states, that's the Ohio story. The cities this last election became bluer, and the suburbs, well, particularly the counties, rural areas, way redder. And that is going to lead to a lot of conflict.
Yeah, so more seriously than my previous answer, I would say there actually are a number of ways to start to build this familiarity. And so one of them that we've already mentioned is teaching classes in this. It's very doable. My law school in particular was very open to this. So, if you're a law professor, you can go to your law school and suggest it. If you're a law student, you can go to your law school and suggest it. Another is the state bar. So does your state bar have like a practice group or, a focus group on, matters of local government? Most of them do. What about state constitutional law? Not all of them do. And then another is thinking about ways to invest in state and local government to have them create long-standing offices that are building up this knowledge base and are available to educate people, to talk to people. So those are all, other ways than reading all these books, but really actually the literature is great in this area and probably underread to get this information out there.
Go ahead.
Richard Samp with the Washington Legal Foundation. I guess my question for Professor Seifter, it's a separation of powers issue. Basically, what should federal courts be doing when they are addressed, they have to decide state law separation of power issues? I'm thinking of the case in the Supreme Court right now about gerrymandering in Virginia, where the the state legislatures say we have ultimate litigating authority over issues having to do how we get redistricted, the Attorney General says no. In the Florida recount situation, the Florida Supreme Court says we are the ultimate arbiter of election results, and the state legislature says no, pay no attention to the state courts, we decide these questions. Are there any neutral principles that federal courts can apply when deciding these state issues, or do they just have to read the state constitution and do their best guess?
This is a really hard and important question, and in my article, actually, I talk about this as one of the costs of the lack of clarity at the state level, right? For all its benefits, it does have this sort of feature where federal courts, and in particular the Supreme Court, actually sometimes denies certiorari because they say this is a vehicle problem. We're not really sure if we're even talking to the right state entity. How to solve it in a neutral way? I mean, I think probably the classic answer would be that they would look to the final decisions of the state Supreme Court if there are decisions on a relevant question, but often there aren't. So I'm not sure that there's a ready solution to this. I mean, you know, other than sort of certification or denying certiorari until the state can sort its own sort of house out.
Sir.
Right. Brian Bishop, and I come from Rhode Island, where for the first 40 years we didn't have a constitution and operated under the King's Charter. But one thing that I observe about our system, which I think I'm wondering for the folks that research state and kind of municipal undertakings, my observation in Rhode Island, and I think it's not actually it fits with the wider 50 states, is that local government is actually far more parliamentary in nature. So while you look very specifically at the delegations, and it's not that they don't exist or that there aren't an alphabet soup of agencies, but the local municipal legislatures and even state legislatures seem much less chary about simply coming in and settling a thing or making literally an individualized zoning decision at the level of a state legislative statute. And I'm not actually sure that that's unhealthy, at least in a small state with very much access to the legislator. That has been far more responsive avenue for myself than the purported responsiveness of agencies. I'm wondering if you've looked at that in your undertakings.
Yeah, so it's a great point, and one of the arguments that people make in favor of local empowerment is that local legislatures can be much more nimble. We don't have a tradition of bicameralism, for example. Again, I mentioned in many local governments there is no presentment equivalent, right? And so local governments can move much more quickly. There is also a tradition, talking about norms, of nonpartisanship. And in actually some states it's explicit. Some local charters, some municipal charters explicitly say that local office holders can't identify themselves by their partisan affiliation. So it's a very different norm. And you do then have the ability in small and even medium size, it doesn't work so much in a place like New York with 8.5 million people and budgets that are larger than many states, but in a lot of smaller local governments and even medium size, you do get very individualized attention and a kind of accountability feedback loop that's very immediate. And I would say the courts have been a little bit chary of that as well. And there is a body of law, at least in the land use context, and it's bled into a few other areas, but it's clearest in the land use context, where courts have looked at legislative bodies, a city council clearly delineated as a legislative body, when they are making an individualized determination. For example, amending a zoning code in order to change the rules for one individual owner. Courts will sometimes treat those legislative bodies as quasi-administrative. And it has generated a really interesting body of law, largely around proceduralizing. So you could have due process rights before a city council. If you think about the Londoner bimetallic tradition, that actually doesn't apply in a lot of local governments. You actually get fairly vigorous procedural rights as a matter of due process at the state level before a legislative body. And I don't know that that's a bad idea. I think that's actually not a bad idea at all.
Arguably constitutionally compelled, because you can't just take people. You can't have bills of attainder. Can't have local bills of attainder. So Londoner bimetallic is important.
which, by the way, were local government cases.
Okay, we'll sit back here.
Thank you, Judge. Alden Abbott, longtime member. I think it's fair to say that regulatory takings doctrine is severely limited under federal constitutional laws, some total destruction of value, that sort of thing. To what extent are state constitutional provisions and state litigation pointing to a broader ability to recover under state constitutional takings clauses? In short, is there more of an opportunity perhaps to find regulatory takings under certain state constitutions? Is there a trend anyone could identify? Thank you.
Judge Sutton?
Well, I mean, I think, so I'll tell you the part of the story I know for sure and the part of the story I'm going to guess at. The part of the story I know for sure is the post-Kelo story, that the state Supreme Courts within a year of Kelo, several were rejecting it under their state constitutions and therefore providing remedies for the plaintiffs in those cases. But those are not regulatory takings. We're talking eminent domain. But just to complete that story, it's a controversial decision, and it's really not just a state constitutional law story. It's a state legislative story. The states really responded very quickly there. So now I'm going to get to the part that I don't know, but I have my suspicions about, that in that stream, you're going to have a lot of state courts now that would be much more sensitive to that kind of argument than I think they would have been before Kelo. I mean, what's really fascinating about how this works between state and Fed is when you get a very controversial U.S. Supreme Court decision that allegedly under-enforces, but it makes the papers, suddenly the state Supreme Courts are all over this. And instead of lockstepping, they're really looking at it independently. And so I think this is an area where state courts are aware of it. They are starting to think independently about it. Whether they're getting very good briefing is another matter. That part I just don't know. And how much they're doing, I don't know either.
Yeah, well, Buck versus Bell was sort of the opposite. So when the U.S. Supreme Court, if the feds say it's okay, then that shuts down. But sometimes you get the Kelo, the opposite effect. Yeah. There's lots of cases in Mississippi, certainly.
And I would just add on, specifically on regulatory takings, you also have a dynamic at the state level, which you really don't have at the federal level, which are state statutory regimes that give property rights recognition. So in Florida, actually, there was a constitutional, an initiative on the books in Colorado in the midterms that failed, but would have had a very similar, essentially a compensation requirement for any regulation that lowers the value of property. So very, very different doctrinal answer to the question of the incidental effects of regulation on property rights. But several states have those property rights statutes. And they operate and they are constraint on regulation and they are compensatory regime. And so that's an important distinction at the state level. Well, and that's not so much constitutional as it is statutory.
Well, the other thing is I think about it and listen to my co-panelists, it's dangerous to pigeonhole these things. I mean, if you read Judge Ouellette's opinion, then Justice Ouellette's opinion in Patel, you really could. The way that is written, it looks an awful lot like a regulatory takings decision. I mean, it's a due process decision under the Texas Constitution, but if you read it, it really is very similar. So I wouldn't think of it purely as taking. I mean, that's really the way he was framing the issue.
Sir.
I'm Kai Alberg from the state of Washington. Our West Coast states have policies on climate change that are very much opposed to those of the current federal government. As a result, you see denials by regulatory agencies of permits necessary to create an export infrastructure for carbon and hydrocarbons, coal from the West Coast. And I'd be interested to see how you would analyze state regulatory agencies frustrating federal policy and in fact interfering with interstate commerce because of an ideological opposition to coal being burned in China as opposed to remaining in the ground in Wyoming.
I'll give one quick idea on this. I don't have a great sense specifically for the West Coast constitutions, but I will say this is a very important point about state constitutions and a very big difference between state and federal constitutions. The federal constitution when it comes to rights is negative, biblical, thou shalt nots, and so forth. State constitutions have lots of positive rights. Emily Zatkin wrote a great book about this, looking for rights in all the wrong places, and making the point that there were education rights, labor rights, and environmental rights. And so I think it's about a third, at least, of the state constitutions that have this. So now you have this interesting dynamic where the state legislature, perhaps with state agencies, has an obligation, and actually an affirmative obligation to protect water, air, resources. But of course, we know there is a supremacy clause, so that's where it gets a little complicated.
Right, I would just add to that, in addition to the affirmative constitutional rights, another difference at the state level is that under most state constitutions, state legislatures have plenary power. So the state constitution limits them. It doesn't enumerate their rights the way we have at the federal level. So, I mean, I think the answer to your question would have to proceed on two lines. One is it legal under state law? And, you know, if the state legislature has said something about this, or if they delegated power to an agency, often that's going to be constitutional at the state level, because unless the Constitution says no, state legislature can presumably do it. But then, of course, there's the federal question, right? So is it actually preempted under the Supremacy Clause? And then you just have to do a close reading of what the federal law is and what the state law is.
And I would just add, you know, I think one of the hardest questions in all of this, when you're thinking about the federal-state relationship, and frankly it plays out as well in the state-local relationship, is do we really have neutral principles that apply across policy disagreements, right? So we get these swings where in one administration, states are asserting policy preferences about immigration, about other areas, and we look to how do we adjudicate those, and then the politics change, and you get a set of different states opposing the federal government, and it is very, very hard, I think, to come up with general neutral principles in the kind of Wexlerian sense to adjudicate that distribution of power. But I think it's the right thing to try to do, whatever your individual policy preferences might be.
I think we've got a little over 5 minutes left, so we'll try to get the next couple questions, and I may offer a parting thought of my own. Go ahead.
I'm Mark Middleman from St. Louis, and this is particularly addressed to Professor Davidson. A great part of our jurisprudence in Missouri on local law is that there is no sovereign power in local communities. Sovereignty is restricted to the state government, but as Professor Seifter has suggested, it's plenary. We have what are called home rule charters, but they're not really total home rule because there's some limitation on what a locality can do through its own city council or whatever is its local legislative body. Do you find this in other states, that there is a difference in the administrative powers of localities precisely because they don't have complete sovereignty?
Yeah, it's a great question. And I have found, again, in the world of our fantasy 90,000 local government surveys, that home rule is one of those areas of state jurisprudence and state constitutional law that varies not only across 50 jurisdictions, and the District of Columbia has its own unique particular version of home rule, but within states. And so you have a range that varies in really broad terms between what we call a Dillon's rule state, where the only power that a local government has is that which is explicitly legislatively delegated from the state, from that exercise of plenary power, versus home rule, which in its strongest form in state constitutional law actually changes that paradigm about where sovereignty rests. And so you have states, and a not insignificant number of states, where as a matter of black letter structural constitutional law, the state constitution actually says that, at least with respect to local matters, and courts have no idea what that actually means, but with respect to local matters, a local government, a city, a county, a suburb, is sovereign. And so it's a choice within the state. If you think about the federal system, sovereignty resides at the state level. Within a state constitution can make a choice to subdelegate, to locate that sovereignty at the local level. And in many states, I can't give you a number because the jurisprudence is all over the place, but in a critical mass of states, as a matter of formal state constitutional law, a great deal of that sovereignty we think of at the state actually resides at the local level. Now, as that has been litigated, and it's been litigated, it gets litigated all the time, State courts are reluctant to recognize that, and I have begun to noodle on an article that I'm thinking of as kind of home rule originalism, because you have a lot of these state constitutional conventions that have adopted home rule. Not only were in the 19-teens in the sort of progressive era, but actually through the 60s and into the 70s. And so the kind of founders or framers debates are really accessible. And you have some home rule constitutional amendments, and New York, frankly, is a good example, where the intent, the founders' intent, was to be fairly strong on the delegation to local democracies, to have a conception that people should be governing themselves at the local level. And state courts haven't respected that at all. So the black letter law of localism in New York, which is the state I know best, the sort of formal structure that we get in the state constitution and the functional structure that appears in the jurisprudence are radically different. And so I think there's an incredibly interesting variety, and we haven't quite figured out what that all means.
Bob Ellickson, he from time to time would say, do you want to be James Madison? Do you want to be a founder? Well, go, get involved in your local homeowners association, because that's where you can establish
really local.
A new polity, and you will be the founder.
One last question.
Yeah, Sam McVeigh, I'm a retired Utah State Court judge. One of the reasons for giving judicial deference to in review of agency adjudication proceedings is that these agencies are supposedly endowed with a lot of expertise and so forth, and the judges are apparently too technically challenged to figure some of these things out. Quote my former boss, though, a judge, paraphrase a former boss, so a judge knows what he or she knows, and a judge knows what he or she doesn't know. So if a judge doesn't know, can't the judge just proceed under Rule 53 of the Federal Rules of Civil Procedure and its state equivalents, get a special master to help them on these technical issues, and forget the agency bias that occurs in when you render agency deference?
If they do know what they don't know, that's great. Yeah, I mean, the judges sometimes have the same problem. Not these.
Ouch. Ouch. This is what happens now that you're a new federal judge. They're not usually explicit about it. They laugh at your jokes in your face, and then when you're not there, they tell you that you're wrong and full of yourself.
So thanks, everyone. Let me offer a bit of a suggestion, perhaps, to Dean and Steve. First, I think, on behalf of all of us up here, thanks for covering the topic and everyone's engagement. I can tell you from just talking to my colleagues on the panel and reading a bit of their work, one of the questions that was coming to mind constantly as I read this was, there's embedded in a lot of the discussion a bit of a normative preference to govern at the local level as much as possible, at the state and local level, for all the reasons that are obvious, closer to the people, et cetera, et cetera. And then as you read some of Miriam and Nestor's work, at least I did, I really realized how much the state, local, municipal, administrative apparatus has grown, and just, how expansive it really is and how many different aspects of our lives it touches. And what also comes to mind is I read very little about it from day to day. The local newspaper has tended to focus on national coverage so much. The local newspaper is not at the end of the driveway anymore. It's fell by the wayside. So one of the questions that I'd encourage the society to consider asking is, are we really able to realize the transparency and accountability that is kind of embedded in this normative preference we have to govern at the local level? Or put differently, are we realizing the federalism benefits that I think are kind of embedded in a lot of the discussion? Are we able to? Or how are we better able to, perhaps? So with that, thank you.